can move. We are back on. Date is the 5th of May, 2020 in Civil Court A. Number 1, case number 657 of 2020 Langholm Farms versus Galanjana and 4 others. It appears there is no appearance yet in this matter, and for that reason, the matter will stand down. We'll move on to number 2 on the roll. Case number 701 of 2020, the Department of Education versus Siapambili Trading, 98cc and another. Mr. Volmarans, I believe you are appearing in this matter.
That is correct, Judge. I appear on behalf of the applicant in this matter. There is no appearance on behalf of the first and second respondent. The first respondent is a close corporation, and the second respondent is a person who is the owner of the close corporation. Yesterday, after I spoke to you telephonically, I made telephonic contact with the second respondent and advised him not to attend court today. He is appearing in person.
Yeah.
I advise that I will postpone the matter to 28 July 2020 with the rule nisi to be extended and costs to be cost in the cause. Your Lordship would have noticed that this is an application for contempt of court, and the second respondent was ordered to file an affidavit by 17 April 2020, which he has not done, and then also further directed to appear before your Lordship today in court, which obviously he's not going to do. But
Yeah.
I have communicated with him, and I will file an affidavit in due course to that effect, and I will similarly get the order of court and do an email to the second respondent advising him of the date yet again being 28 July 2020. So accordingly, I would seek an order that the rule be extended to 28 July 2020 with costs to be cost in the cause.
Yes, thank you, Mr. Volmarans. The matter is postponed to 28 July 2020. The rule nisi is extended accordingly. The costs are to be costs in the cause. The applicant is ordered to serve a copy of today's order on the second respondent.
My Lord, if I can just request, or with understanding, that the order will be served via email. The previous order was also served via email, and I've had confirmation from the second respondent that he accepted service in this fashion.
Yes, thank you for that, Mr. Volmarans. The order will be served via email.
As the court pleases.
Thank you, Mr. Volmarans. The next matter on the roll is the Mr. Volmarans, you may be excused. Mr. Volmarans, can you hear me?
My camera, but what I do is I've heard you and I will excuse myself from the meeting then further, Judge.
Thank you, Mr. Volmarans.
Thank you.
Excused. The next matter is number 3 on the roll, 693 of 2020, Kilian versus the Road Accident Fund. It appears there is no appearance for this matter at present, and the matter will stand down. Mr. Woodrow. Mr. Woodrow, we are now dealing with number 4. I believe you appear in this matter.
Thank you, my lord. I appear in number 4 and number 5, I believe it is. It's matters 48 and 49 of 2020.
Yes.
48 and 20.
Number 4, it's case number 49 of 2020. Engelbrecht NO and others versus Jubei. Number 5 is 48 of 2020. Engelbrecht NO and others versus Jubei. I would ask that we deal with both matters simultaneously.
As it pleases you, my lord, there's a large overlap between the two. The one is for default judgment, as you're aware. That's number 5. In respect to the same causes of action that are set out in matter number 49 of 2020, which is a sequestration application.
Yes.
My lord, your lordship will have noted that the court order granted on 21 January 2020, which is contained on page 1 through to page 3 of the sequestration papers, was an order for attachment ad fundandum jurisdictionem, alternatively ad confirmandum jurisdictionem, and that leave was granted to the applicants to institute the application proceedings by way of edictal citation and the action proceedings by way of edictal citation, my lord.
Yes.
My lord, your lordship granted that order on the 21st of January, I believe.
Yes, if I may interrupt you,
Yes, my
take
lord.
you to paragraph 3 of that order,
Yes,
which made provision that the applicant or plaintiff had 3 alternatives on how to serve the order in New Zealand.
yes,
It appears on page 191 of the papers.
yes, my lord. It's the affidavit, the service affidavit of Mr. Franz Johannes Rabi, my instructing attorney of record. And I'm with you, my lord.
Yes, if you look at paragraph 7.2, it raises an issue which I think is correct. This service was effected in another jurisdiction beyond the borders of this country. So a
Yes.
return of service on its own would not suffice. What is required, as reflected in that paragraph 7.2, is an affidavit which indicates the authority of the person who served the process. It says here it's attached as FJR7. But if you look at
Yes.
the index, there is no FJR7.
Yes, yes,
The papers only go to page 208.
yes, my lord.
Same holds true for the other matter. There is a return of service, but there is no affidavit accompanying that return of service.
Yes, I have taken instruction, my lord, from my instructing attorney, who is with me today, and it's due to the lockdown that affidavit was not obtained due to the lockdown in New Zealand. Apparently, that the affidavit was not obtained. But your lordship will have noted that there is a return of service on page 207 and 208. And I say a return of service, I understand it's a type of return of service from New Zealand. I'm not an authority on New Zealand law, obviously, but it deals with the manner in which service took place. And the attorney does confirm in paragraph 7.1 that the in paragraph 7.1 on page 190 to 191 that it was served on the 15th of February 2020 personally on the respondent defendant. And he attaches those returns of service FJR 6. My Lord, I hear...
I'm sorry to interrupt. I wouldn't even insist on an original. If this had been emailed from New Zealand to you or to your instructing attorney and transmits it onwards to the court here, I don't think there would be an issue. The only reservation I have is that this is another jurisdiction, and I don't know if the lady Vanessa Becker has the requisite authority to serve this in New Zealand. That's my only concern.
I understand, my
That had
Lord.
been addressed in an affidavit by Vanessa Becker, I wouldn't have any issues with both matters. And it doesn't appear to me there would be an issue with both matters, even to any of my colleagues, if I may be so presumptuous as to say that. Is it such a difficult thing to obtain this document?
My Lord, it was apparently, because I've seen email correspondence in terms of which a request was made, and the return email from the process server in New Zealand was that even at court it was difficult to obtain commissioning of affidavits. But that was then. I don't know whether the lockdown is still in place as such in New Zealand. It may be possible.
That's the next point I was going to raise, that if the news reports are correct, New Zealand has had its lockdown lifted. Apparently, they are more successful than most with containing the COVID-19 pandemic. Would circumstances not have changed this week, such that if we postpone for a week, you may be able to obtain the order next week with all the requisite document filed?
My Lord, would it be a possibility for and I speak out of ignorance in the sense that I don't know what your availability is or what your role, how your role is going to be worked with. But your Lordship obviously has knowledge of the facts of this matter and has read the papers, which are they're not massively voluminous, but they are 300 pages in total, more or less, if we take both applications into account. May I ask whether it would be appropriate or to seek an indulgence to stand the matter down till later in the week for your Lordship?
I have what appears to be an involved matter on Thursday. Ordinarily, I would have said, let's postpone to Thursday because I've read the papers. It's only for me to receive the affidavit and deal with it. Perhaps we may try that, postpone it to Thursday on the understanding that your instructing attorney will transmit the affidavit to us, and I consider the matter on Thursday then.
My Lord, thank you. If that is convenient, then we would request that it stand till Thursday, as you've indicated.
I understand you are not practicing in this division, but the practice rules in this division, practice rule 8C, provides that even in an unopposed matter where the papers exceed 100 pages, heads of argument have to be filed.
I apologize for that, my Lord, and I'll ensure that those are filed before Thursday. I filed a practice note, but not heads of argument.
Yes. So the matter will be postponed to Thursday, and the costs are costs in the court.
As it pleases you, my Lord, and that's in respect to both matters, I understand.
That's correct.
As it pleases you, my Lord.
Yes, a similar order will issue for both number 4 and number 5. The order is to the following effect. 1, matter is postponed to 7 May 2020. The costs are costs in the course.
As it pleases you, my lord.
Thank you,
Shall I-
Mr.
may I-
Woodsboro. You are now excused.
Thank you, my lord. I see that there are some others waiting, my lord, in case you haven't seen
Yes.
them. I'll exit. Thank you.
Thank
As it
you.
pleases the court, my lord.
Mr. Delahab, can you hear me?
Morning, Judge. I can, Judge. Thank you.
Yes. I had called your matter earlier, but due to the technical difficulties, I had stood it down. It's number 1 on the roll.
I'm grateful, my Lord. There are going to be lots of technical difficulties, I'm afraid.
Yes. It's just teething problems. We will get used to this. We are all new
I
to
hope.
it. After-
Judge, I have two matters on that I thought were on your roll. We haven't seen your roll, so when you refer to the first matter on the roll,
I was
Lord,
going to call
is
it
it the
now.
Langholm? Yes, thank you, Judge.
Number 1 on the roll is being recalled. Case number 657 of 2020, Langholm Farms, Pty Ltd versus Galanchana M and 4 others. Yes, Mr. Tilahab?
Thank you, my Lord. You will have seen, my Lord, that on the 24th of March, the applicant sought and obtained directives of the court regarding service in terms of Section 4 of PI,
Yes.
and the directions for service required were designed to give the respondent cited 14-day opportunity before the hearing of the matter, which was determined to be the 5th of May. Of course, what has happened, judges, is the lockdown has affected two things. The first is that the sheriff did serve the order issued, but not timeously, Judge, my lord. So that's that's put the kibosh on that. His return of service has also not reached us because he tells us that tells my instructing attorney that his system is down, whatever that may mean. But in any event, my lord, evictions are no longer competent during the period of the lockdown, as you have seen from the regulation. And so what we seek, my lord, is a further order in terms of Section 4.2, which we did email to your officers. But I don't know whether you have it before you. We can send it again. But may I speak to it and just say to you, it's the same order, my lord, as was issued by Mr. Justice Takota on the 24th of March, save that the date that we have selected in the hope that the lockdown will have been eased further is the 9th of June, my lord. So it's an identical order, except so we'll repeat the process required by Section 4 of PI in terms of an additional and further order, affording the respondents another period. And so that is that we would move for that order. And my lord, if you don't have it, we will email it immediately to your registrar again, because we've redrafted the order so as to facilitate matters in the registrar's office as well.
Yes. I am familiar with the order by Tokota J. I just wish to raise one thing with you, Mr. Tilahap. This
Yes, my lord.
concerns the issue of language. I noted that the order makes no provision that it be translated into Xhosa or whatever the language the respondents use. so that the sheriff reads the order in the language the respondents normally use. You would be familiar with the SCA decision on this point in Cape Kilian versus Mahamba, I think.
I am, my Lord.
Yes. If
Lord, we will.
if you would just
if we-
amend it to include that provision, then
Yes.
I will make the draft order an order of court in chamber.
So, my
Your
Lord,
instructing attorney may send someone to collect the order from the registry.
Thank you, my Lord. And so what we propose, what I propose then, my Lord, is that we amend this order now and email it directly to your registrar,
Yes.
in accordance with your requirement, and then make contact with your registrar later to uplift the order if my Lord is happy to have issued.
Yes, I would go along with that. That would be in order.
Thank you, thank you, my Lord. My Lord, might I mention the other matter?
Yes, you said you had another matter, Mr. Dilahar.
Yes, my Lord, we've been in email communication with your registrar about a matter which originally served before Mr. Justice Smith at the first week of the lockdown, and then it had a return date which was of course set for the end of the first period of the lockdown, and now of course is needs to be extended further. My Lord, it is the matter of Truda Foods versus Chris Harney Municipality, and my instructing attorney, Mr. Nettleton, has also been in communication with your registrar on the matter, because she was having difficulty yesterday, as we understand it, finding the file.
Yes.
So we try to be of assistance by advising that the matter, as I said, was initially served before Mr. Justice Smith, and then the rule, the return date was before Madam Justice Majiki, and was postponed, and the rule extended to today. I don't know whether the file has been located, my Lord.
Not as
Because your
yet. I say that because it's not been presented to me.
I see.
If I understand you correctly, you seek that the rule be extended.
Yes, my Lord.
May we do it this way? Immediately I adjourn the proceedings. My registrar is going to phone your instructing attorney, or do you have a case number with you for this matter?
I do, my Lord. It is 800 of 2020.
800.
We did I conveyed that to your registrar. There is also, I might mention, my Lord, now opposition, it seems rather tentative opposition, though, my Lord, by the first and second respondents, and so there is actually agreement now that the matter be postponed to the 19th of May, and the rule extended accordingly, with the respondent to file answering papers by the 8th. This matter, my Lord, it concerns the COVID issue, and trading of a food processor in Queenstown.
Yes.
So it conceivably could be heard during the period of the lockdown, although, yes, I mean, I shouldn't venture any further opinions about the matter.
Yes. Would it be convenient for you to email my registrar a copy of the draft order as agreed with the respondent's representative, so that when I locate the file, I have a copy of the draft order and I can then make that an order of court?
Thank you, Judge. My Lord, that's exactly that would suit adequately. I will attend to all of that, and then email it to your registrar, and if you would make an order in terms of that agreement.
Yeah.
Thank you, my lord.
Yes,
Thank
thank you, Mr. Tilahap. You are now excused.
Thank you, my lord.
It appears the legal representatives appearing in matter number 3 on the roll, 693 of 2020, have not yet joined the meeting. In those circumstances, the court will at this stage adjourn.